So class, up to this point, we've been talking about how we go about making decisions for people who are within their sound mind and judgment. Today what we're going to do is we're going to begin to talk about how we go about making decisions for those who are no longer able to make medical decisions for themselves. Now, I know some of you who are a little bit older may have already had to experience something like this. Maybe you had to make a medical decision on behalf of your mother or an uncle or your father. And some of you who are a bit younger may never have confronted this yet. But this is the kind of thing that's important to think about even now, because you never know when something tragic might happen and you might be put in a situation where you're being asked to make medical decisions on behalf of a family member. I actually had a friend a few years ago who was only 25 years old, and his mother suffered a catastrophic health condition, and she was on her deathbed, and at 25 years old he was in charge of making medical decisions for his dying mother. So it's something that could happen at any point, and it's always best to do preparation so that you're not making the decision or having to think through it when it's matters of seconds or days or hours are really critical. It's good to do it now while you may have some actual time to sit and reflect on your decisions. So there are a host of types of decisions that you might be asked to make on behalf of someone else, or maybe even someone else might be asked to make on your behalf. I have a few listed right here as you can read along. For instance, you might have to make a decision about whether or not to withdraw or insert a feeding tube into someone who is in a comatose state. You might have to make a decision on whether or not to place someone on a ventilator or to remove them from one. Another decision you might have to make is just any kind of general withdrawal of treatment or to start certain treatments on behalf of another person. When we're discussing making decisions for incompetent patients, it's important to keep in mind exactly whom we're talking about, because there are various degrees in which a person can be deemed to be incompetent. Incompetence isn't just an all or nothing affair. It's not as if a person is either they're in a complete and total state where they can make a decision for themselves, or they're in a complete state where they can't make any kind of decisions whatsoever. There's a range in which we could discuss someone's competence. There is, for instance, people who are severely demented. For instance, if someone is suffering from dementia or Alzheimer's, and they're no longer in a state where it seems like they're of sound mind and judgment. If this is the case, we wouldn't think that it would be appropriate, for instance, if someone is suffering from dementia or someone suffering from Alzheimer's, we wouldn't think it's appropriate to just simply ask them, hey, what do you want? Because they're not really in a position to make a decision about what they want. People who are in that late stage of degeneration, they're often very susceptible to suggestion, or maybe they're very hostile to suggestion, even when it would be to their benefit to undergo treatment. And so people in those conditions might need someone to make a decision on their behalf. Like I was saying, in addition to having different types of incompetence, there's also a range in which people are incompetent. For instance, there are people who are minimally functional, and someone who is minimally functional. You see, I skipped one here. I should back up a little bit. There are people who are marginally functional, and what that means if someone is marginally functional is just that, by and large, they seem to be mentally present, but there are episodes where it's not really clear that they're with us, so to speak. My grandfather, when he got a bit older, was like this. He was pretty cogent. He was pretty coherent. I mean to say, for the most part. But then he would just say things that seemed like he wasn't fully aware of what was going on. I actually had a friend of the family who he was pretty aware and could understand what was going on for the most part. But then sometimes he would just slip into being back in World War II. He had fought in World War II, and occasionally he would just start talking as if he was actually there. But for the most part, he seemed to understand what was going on. There are people, and they're going to, we're talking about marginally functional. again, even within the range of marginally functional, there are ranges which people can fall in. There are the minimally functional, people who just they're the kind of opposite of marginally functional in a way. It's like for the most part they're not mentally present with us, though they might have brief episodes where they seem to be aware of what's going on. Then there are people who are even further far gone, who are in a permanent vegetative state, where there's just they're not in any way, shape, or form showing any explicit signs of self-awareness or consciousness. They're just and maybe they could be in a coma. Maybe they could just they could be alert, but there's no higher functioning taking place, so to speak. Now, the person who makes decisions on behalf of someone who is deemed incompetent goes by several different names. We call them the surrogate decision maker. We might call them the proxy decision maker. There are different names they go by, but anyone who makes a decision and is given authority to make decisions on behalf of someone else is known as the surrogate. In most cases, the surrogate will be the spouse of someone. For anyone who's an adult. For instance, if you're an adult and then you undergo like massive brain trauma or something and you can't make a decision for yourself, your spouse would be the one who legally that falls to, unless you've appointed someone else specifically in a written authorization, then it may fall to someone else. After your spouse, if you have any adult children, it will typically fall to your adult children to make decisions for you. Beyond that, it may fall to your parents. If, for instance, you're an adult and then you don't have, I don't know, let's say you don't have a spouse, you don't have children, then it might fall to adult children, I should say. We're not going to ask a 10-year-old to make decisions. Then it might fall to your parents in that case. It's kind of interesting because, in my opinion, because you would think that after your spouse it would fall to your parents, but it actually, in most cases, falls to your children. Then it would go to your parents, then maybe any other living relative. And if none of those are available, and there are protocols in place for all of this, then it might actually be that a doctor, or it would probably be the hospital with a board, would be making decisions on your behalf. Anyone basically who's making medical decisions, we're going to call the surrogate, or we'll call the proxy decision maker. And there are lots of questions that come up when we start talking about how we go about making decisions on behalf of people. One big question is exactly, even though I was just going through and explaining a little bit about how we make a decision of who the surrogate will be, it can be a little tricky at times, and it can be problematic. For instance, if you have, there was a famous case years ago involving Terry Schiavo, whom I believe I mentioned in an earlier lesson when we were talking about personhood on our topic of abortion. But with respect to Terry Schiavo, her husband wanted one decision, and her parents wanted a different decision made for her, even though she was deemed incompetent. But you might have a case also involving where two children of parents want something different. Maybe one child of a parent wants the parent to be allowed to die. Maybe another child wants the parent to be kept alive. You could raise questions like that with respect to how they would go about making how, I shouldn't say they, but it would be determined who should be the surrogate for the parent. But what we're going to focus on is, let's just assume we've decided who the surrogate is going to be. What types of considerations should the surrogate appeal to when they're making a decision for someone who has been deemed incompetent? So, like I said, we've made a decision. We know who the surrogate is. We're going to say, that's completely settled in this case. We're not worried about figuring out who is the most appropriate surrogate. We're not even worried about whether or not what we judge to determine if the person is deemed incompetent. That's another question. Exactly when does the person become incompetent? We're just going to assume we're dealing with an incompetent patient. We're dealing with a clear person who's been determined to be the surrogate or proxy. Now, what does the proxy or the surrogate appeal to? What basis do they use to make a decision on behalf of this incompetent patient? And what most people think is that what a person who's a surrogate should appeal to is basically what the incompetent patient would have wanted. We typically think that we should appeal to what is called an autonomy-based standard when we try to make decisions on behalf of the incompetent patient. And the basic philosophical justification for this is it seems that if the person were alive and were able to make decisions for themselves, then we should respect that person's, I shouldn't say alive, but if the person was conscious and present and was able to make decisions for themselves, we should respect their autonomy. We should respect their wishes. And so what the surrogate is trying to do ultimately is to, in a way, in a more distant way, respect the autonomy and wishes of the incompetent patient. They're not here to make that decision, obviously. They're not conscious and present and capable. But what we want to do is try to respect their decision, the decision they would have made, to the extent that we can. And there are several different ways that we go about trying to do this, and ways we try to go about respecting their decision. But what a lot of times is discussed in connection with this is what we might call precedent autonomy. Precedent autonomy is basically just any kind of autonomous decision that the person made prior to their incompetent state. And so in a way what we're trying to do is figure out what the person's previous decision was before they became incompetent, and then respect that. Now this gets really tricky because we're trying as best we can to respect the wishes of the person who's been deemed incompetent. But exactly how do we determine what their past preferences might have been? How do we go about figuring out what they actually wanted? What types of evidence do we appeal to in order to respect the incompetent patient's autonomy? Because hopefully I'm not belaboring the point here, but currently if they're incompetent, they no longer have autonomy. What we're trying to do is figure out what their autonomous wishes were in the past. So we have to be somewhat detectives here. We have to figure out what they would have wanted. And one piece of evidence that we use, and this is considered typically to be, I guess, the gold standard, would be what we refer to as an advance directive. And basically an advance directive is just any legally signed document that describes a person's preference regarding medical treatments that they might be administered if they are deemed to be incompetent. And there are a number of different types of advance directives that a person can leave. Basically, one of these would be called a living will. Now, I'm sure a lot of you are familiar with a will that a person can leave. Typically when we think of wills, we think of documents that a person signs in which they leave their property or their belongings to relatives once they have passed away. But a living will is basically a document that specifies types of medical treatments that a person would desire in the condition or in the event that they become incompetent. So it might say something in a living will, for instance, such as, if I am deemed incompetent, I do not want to be intubated. Or if I am deemed incompetent, I don't want to be kept alive if there's not a reasonable hope of recovery. And you can write a living will to specify pretty much anything you want. And the idea of respecting the living will is that in doing so, we're basically respecting the past wishes of the person. That this was a judgment that the person made while they were competent. It's a legal document. They sign it, and now that they have been deemed incompetent, we're just trying to respect that. Another type of advance directive is what is called a medical or healthcare power of attorney, and this is, again, it's a legal document that you sign, and you basically just give another person complete control over making decisions for you. So this would be, once you've been deemed incompetent, this would kind of kick in, and whomever you want, you could give them power of attorney. You could give your aunt, your sister, your anyone who's 18 or older. I don't think you would be allowed to give a minor power of attorney. You couldn't give your cat, obviously, power of attorney. People try to do crazy things, but it'd have to be a competent adult, and it would just be a way of basically specifying whom you want to make decisions for you. You can also sign a DNR, do not resuscitate order. And actually, when you undergo surgeries, I think they typically require that you do sign a DNR. Now, an advance directive is great, but it turns out that not everybody creates a living will. Not everybody has the inclination to do so, or they think about it, or they have the time or the concern. I don't know that everybody necessarily has signed a DNR either. If you go to have a surgery, I think you're required to, but if you're just a healthy person running around in the world, you may never think, well, let me fill out some legal documents to specify what happens to me in the event that I become incompetent. So for a lot of people, they don't have advance directives to inform their surrogate or proxy what they would want done. And when so happens that there is no advance directive laying around, then the next level of evidence we appeal to is what is called an oral directive. And these are basically just spoken statements expressing a person's medical wishes. And you may have heard a family member, for instance, they'll just tell you, like, well, if I'm ever in that state, don't allow them to put a feeding tube in me. Or if I'm ever in such and such state, just allow me to die. And an oral directive, I mean, it really is, kind of like a gentleman's handshake in a way. It's just, it's not a legally signed document of any kind. It's just a family member or friend just expressing their wishes. This actually goes back to the case I was mentioning a second ago about Terry Schiavo, whose parents wanted to keep her alive, and her husband wanted to allow her to die when she had been deemed incompetent. And the husband's entire case, as I recall, rested on the fact that she had told him, I don't ever want to be in this state, and if I ever am in the state, just allow me to die. Oral directives might be, as kind of fleeting as I've just indicated, where someone just tells you, hey, if I'm ever in the state, just allow me to die. They might be, more deliberate conversations like you might have with your spouse or your parents or your children, in which you just maybe walk through and tell them all the things that you do or don't want, or maybe they walk through and tell you all the things that they do or don't want. So, this is kind of a next level piece of evidence. As I said, kind of the gold standard would be an advance directive, because this is a written or legally signed document. Then we have, after that, oral directives, where we lack advance directives. Then maybe the person might state their wishes, and so we appeal to that. And both of these are, as I said, they're attempts to uncover what the person wanted, because ultimately the goal is to respect their wishes, to respect their free choices for how they wanted to live their life. This is, when it comes to medical ethics, this is one of the big issues, the big key issues, respecting what the patient wants. This is something that is a huge issue in medical ethics. So what do we do, though, when we lack an advance directive, we lack an oral directive? Well, then what sometimes is attempted is what we call, or appeal to, is what we call substituted judgment. Now, this is different from the previous two. With an advance directive, we have a written document saying, I want X, Y, and Z. With an oral directive, the person physically tells us, I want X, Y, and Z. But what if someone does neither? Well, then in those cases, what we try to do is figure out, based on our knowledge of what that person wants, or based on our knowledge of that person, what they might have wanted in this situation. Now, I'm sure a lot of you, you've known someone for years, you've been around them a long time, and so you just kind of know what that person wants. You know the things they like. You know the things they dislike. in just having been around them, you can kind of figure this out. I think about, for instance, my girlfriend, and sometimes I'm walking through a store and I'll see something. I'm like, oh, she would like this. And it's not because she's ever, physically pointed to this object and said, hey, buy me this, or anything like that. It's just I know her, I kind of know her interest, I know the things she likes, and based on that, I can figure out and infer that she might like these other kinds of things. So when it comes to substituted judgment, I mean, here is really a case in point where it requires an intimate knowledge of the person. And I don't mean necessarily romantic knowledge. I just mean that you have to have known the person for a long time. And what you're trying to do is you're trying to say something like, well, it's something like the following. It's like, well, I've known Deborah for 40 years. I know that, she would have wanted this, or she wouldn't have wanted this. And there are a number of things that we can appeal to when we're trying to make an attempt to figure out what the person would want. We might know, like, for instance, their religious beliefs. They might have been deeply committed to a particular religion. For instance, Jehovah's Witnesses. They don't believe in blood transfusions. So let's say you had known, go back to the name I used a second ago, Deborah. You'd known her for years and years, and like, I knew Deborah was a deeply committed Jehovah's Witness, and I know that she, wouldn't have wanted a blood transfusion. She was always opposed to them. That's the kind of thing that you could appeal to. Or you might appeal to, maybe certain kind of desires or preferences they had exhibited throughout the course of their life. For instance, if they had always been, just kind of wary of going to the doctors, they didn't like doing it. These sorts of things might be really significant, even if they never explicitly said, I don't enjoy going to the doctor, or I don't like being in hospitals. Just knowing, them and how perhaps maybe they had avoided going to doctors might be important in making this kind of substituted judgment. There was actually a really famous case of just this in 1983 involving a woman named Claire Conroy. And as I recall the details of this, she basically she was deemed incompetent, and the doctors, I should have looked this up, but I believe it was in the state of New Jersey. The doctors wanted to perform a medical operation on her, and her nephew wanted just to allow her to die. And this made its way through various courts. And what the nephew argued is that she was not the kind of person who ever liked going to see doctors. She never went there. She always avoided doctors at any attempt she could. She had been hospitalized previously, and she left immediately as soon as she could. She had refused the amputation of a gangrenous leg in 1982. And in her present state, even though she was incompetent, she was regularly trying to pull out the feeding tube that had been inserted in her. And it was deemed by the court that her nephew didn't have any kind of clear, malevolent or evil kind of intention, that he really cared for his aunt. In fact, I believe he was her only living relative. He visited her every week. It wasn't, this kind of thing where he was just trying to get her money or anything like that. It was actually a sincere relationship he had. He did know her very well. And the court ruled that based on his testimony, that she probably would not have wanted I believe it was to continue to have the feeding tube in her. And so they decided to go ahead and remove it, and she was allowed to die. So you can see here that basically she never left an advance directive. She didn't have any explicit oral directives, but just based on a pattern of behavior, it was determined what she would have or would not have wanted in this particular case. This is what we call the substituted judgment standard. And just to give you a kind of picture of how this breaks down, the basic question we're asking here is, what standard should we appeal to when we're making a decision for incompetent patients? And there are two broad different kinds of standards. We haven't talked about the one over here on the right. We'll get to that in a moment. But there is what we call the autonomy-based standard. And when we appeal to the autonomy-based standard, what we're trying to do is respect the wishes of the patient. And then the question we have here is, well, what is our evidence for their wishes? And then we have an advance directive, which is, again, like the things I mentioned, a living will, DNR, power of attorney. These are written documents. Another type of evidence we appeal to in the event that we don't have an advance directive is an oral directive, where the person explicitly tells us, I want X or I don't want X. And then finally, we have substituted judgment. And this is where we try to figure out what the person would have wanted. And the truth is that even though I presented these as, we start with advance directive. If we don't have that, then we move to oral directive. If we don't have that, then we go to substituted judgment. But in some cases, the evidence that we're presented in each one is maybe not entirely clear, and so we can use those in conjunction. So we might have, for instance, an advance directive, and we're like, oh, a little unsure exactly what they were saying, but we also know that they said, X, Y, and Z, so that helps us understand their advance directive. And then we might also have substituted judgment, where we know the person's history. So even though I presented these as we start with advance, then we move to oral when we lack advance, and if we lack oral, then we move to substituted judgment, they can work in conjunction with each one. Now, this is the way we proceed. The first thing we try to do is respect the wishes of the patient. But here's a question. What do we do when the patient doesn't have, there's no clear evidence of any preferences that he or she may have ever wanted? For instance, they don't have an advance directive, there's no oral directive, and their pattern of behavior doesn't provide any clear evidence of them liking the doctor or them not liking going to the doctor or anything like that. What do we do basically when the autonomy, we have no evidence of their wishes? The autonomy-based standard, I don't want to say it fails, but there's certain limitations to the autonomy-based standard, because in order to apply it, we do have to have some evidence of their wishes. Not only that, but what do we do in the event that the person was never competent to begin with? For instance, someone who was born with Down syndrome, or they lived their whole life, they would never in a condition where they could, or state where they can make medical decisions for themselves. Or what do we do when we're dealing with children? Maybe children who develop cancer at a very early age, 4 or 5 years old, and they're not able to make medical decisions for themselves. How do we make decisions in those cases, basically where the autonomy-based standard fails? The autonomy-based standard is, kind of the first thing we go to, but it does have certain limitations, and it can't always be applied. Like I said, it can't be applied in, number one, cases where the person never provided clear evidence, but then also in cases where the person was never competent to begin with. Well, when the autonomy-based standard fails, then we move on to a different kind of standard, and that is what we call the best interest standard. And here what we do is we say, all right, well, let's not worry about what the person would have wanted. Instead, let's try to figure out what is in their current best interest based on the pain they're in, the expected quality of life the person might have later on, and then try to figure out what the average rational person would want in this current set of circumstances. Because we can kind of figure this out to an extent. It's like, oh, look, I don't have any evidence as to what you would want, but most people in your circumstances would probably want, X, whatever that is. For instance, if, the person is not competent, and in order to keep them alive, you have to, put them on a ventilator, but they're only going to have to be on the ventilator for, 5 hours, and then afterwards they could be taken off, and they'll have, a full, rich life after that. Well, most people would want that in that case. There might be some people who are like, no, I don't want to be on a ventilator, just let me die. But the vast majority of people would say, well, if it's only for 5 hours, I could tolerate that if I'm going to have, 30 years of life afterwards, of rich, full life afterwards. On the other hand, if it was the kind of thing where it's like, all right, well, we have this extremely painful procedure we can perform on you, the chance of success is extremely low. There's 1 in 100 million, and then afterwards, you're only going to get to live for 6 months, in which will be in agonizing pain anyway. If it was something like that, I think most people would prefer not to undergo that. They would just simply say, well, it's going to be painful, I have a low chance of success, and then afterwards I have a very terrible quality of life that's going to be very short afterwards. So I would prefer not to have that. Like I said, this is not a standard in which we're trying to figure out what this specific person wants, but rather just what the average person would want if they were in their situation. And when it comes to the best interest standard, there are two types of tests. And one is what we call the pure objective test. And this is just based solely on the current best interest of the person. In this case, we're just like, all right, what's good for them now? And that's the only question we're basically asking. In addition to that, we also have what we might call a limited objective test. And basically, this one is where we're trying to, in some way or another, use some elements of the autonomy-based standard. We're saying, well, look, we kind of have a sense of maybe what they would want, but let's also weigh what they would want against what's in their current best interest. Let's use both of those in a way to make a medical decision on their behalf. Now notice this is different from just applying the autonomy-based standard by itself, because when you're applying the autonomy-based standard by itself, you're not at all interested in what the average rational person would want in this situation. When you're just applying the autonomy-based standard, you're just saying, you know, this person said they wanted X, so we're going to give it to them. Now what we're doing is saying this person said they wanted X, but let's also bring into the equation what the average rational person would want. And let's try to figure out, you know, the medical decision based on those two things combined. So this is a little trickier in certain ways because you are combining elements of what's in their current best interest, and you're also trying to combine elements of what the person would have wanted. And again, this is we do this when we have just maybe the smallest little piece of evidence of what their past preferences may have been. So just to flesh everything out in detail, here we have the two kinds of standards that we use. We have the autonomy-based standard over here, and this is what we go to first. When this runs into limitations is when we don't know what the person would have wanted. They leave us no evidence whatsoever of an advance directive. They leave no evidence of an oral directive. They leave no substituted judgment. So when they leave no evidence, or it runs into limitations when the person was just never competent to begin with. And when they weren't, then we applied the present best interest test. And this has two forms. There is the pure test, which is just the only question we're asking is what is good for them now? What would the average person of reasonable intelligence want right now? And then we also have the limited best interest test, which is where we try to combine some elements of autonomy with with what is in their current interest now. So what we're going to do in the next video lecture is we're going to look at philosophical problems that are associated with some of these types of decisions. In particular, some of the problems associated with autonomy-based standards. But the purpose of this particular lecture was just to give a survey of these different types of standards that are appealed to for incompetent patients.